So here's a red flag in hiring a personal injury lawyer that I want to tell you about. It just arose yesterday. Someone called our office and wanted to fire their current lawyer, who is a big TV, sort of advertising firm. And when she got their fee agreement, in it, they were including something called an arbitration clause. Basically says any disputes you have with this law firm, you can't sue them in court. You have to go to arbitration. Now, why do they want you to do that? Because it's a lot harder, it's a lot more expensive, and you're less likely to do it. And also less likely to win. So we don't have that clause in our contract. And I really think that it's kind of wrong for a personal injury law firm to make you waive your right to a trial by jury. I mean, that's something we believe in deeply, at least in our office, at our firm. Tennessee Constitution, where we're licensed, the right to trial by jury shall remain inviolate, is in the Constitution of the state of Tennessee. And, we're always talking about the 7th Amendment, which is the federal version of that, and the right to access the court system. That's why we oppose a lot of laws like caps on damages that make it harder for plaintiffs to get justice, because juries will make an award. And, if you have a cap, that's replacing the role of the jury. And I bet you that this same law firm that has this clause in their contract says all those things, publicly, but then puts this arbitration clause in their contract. So I'm here to say today that that is a red flag. If a personal injury law firm has an arbitration clause, that means that they don't really believe in the trial by jury. They don't believe in the right. They're not walking the walk when it comes to that. And, maybe it's fine because maybe they'll do a great job representing you and everything will go smoothly. But if it doesn't, and they commit legal malpractice in your case and you want to sue them for that, as you should be able to, well, they're going to make you waive the right. And there's something else I want to say on this. This specific example, this lady called to say, I want to talk to the lawyer on my case who will be handling this because I don't like this provision. I don't like this arbitration clause. And she couldn't get the lawyer on the phone. So that goes back to something else I've talked about in other videos about, the thing about big injury firms, the ones that are all over the television airwaves, is that a lot of times it becomes a volume game, and the individualized attention is not something that you're going to get. And it's even worse, I think, if on top of that, then they say, and if we mess up, you don't get to sue us in court. You have to go to arbitration and you have to prove your case, because that just makes it so that it's almost, it's a complete barrier. Let's just put it that way. They do that because it makes it harder on you to sue them. It's the same reason that nursing homes put it in their contracts, because they want to compel arbitration and avoid lawsuits. Probably from the same kinds of injury firms. In fact, I wouldn't be surprised if the arbitration clause that they're using was lifted from something like a nursing home or, an apartment complex or something like that had, an arbitration agreement that had been used against them at one point. I mean, that's speculation, but you see my point. They're doing exactly the thing that they try to fight against when, it suits them. So I don't know. This is just sort of a rant video more than anything else, but it's also a promise that if you ever contact us, you will never see an arbitration agreement in our fee contract. So if you want to watch those videos about, our thoughts on big law firms, click the next one. Thanks for watching.